Okay, I think our virtual guest list has stabilized, so I think people have joined. Hello and welcome everyone. My name is Chad Cadwell. I'm a partner at Herbert Smith Freehills, and I'm delighted to be moderating today's event, which is quite a special event really. It's a joint event with ACICA45 and HK45. We're going to be exploring the role of courts in support of arbitration. But I just want to pause momentarily to note that that how fantastic it is to be able to use these platforms to have these two groups that support young practitioners working together and bringing us all into one place. It's particularly pleasing for me as someone who grew up in Adelaide, and we're live in person in Adelaide today, spent some time in Hong Kong enjoying HK45 events, and then came back here to Australia to replicate that model, being part of the group that set up ACICA45, to see it all coming full circle today with this joint event. And so before before I introduce the panelists and we kick on with proceedings, I did want to introduce Mariel Dempsey, who's a partner at CMS in Hong Kong and also part of the HK45 committee, to just say a couple of words on behalf of HK45.
Thanks a lot, Chad. Good morning, good afternoon, everyone. I know many of you were expecting to see Eric here today, but he had a last-minute emergency, so I've stepped in. Thank you very much for the kind introduction, Chad. As Chad mentioned, I'm a member of the HK45 committee, and as an Australian who lives in Hong Kong, even though I'm not there right now, this is obviously a topic that's very close to my heart. But what I'll do first, and in order not to hold you up from actually listening to the panel, is just give you a very brief introduction about HK45. So as many of you know, HK45 is the HKIAC's younger group, and it aims to create thought leadership and networking opportunities for young arbitration community members in the region and obviously in Hong Kong, but also further abroad. We have a number of events. We are also doing a fireside chat event highlighting diversity and inclusion in international arbitration, which is now in its third series. And as Chad mentioned, this is a particularly special event here today because, as far as I know, and I'm sure someone will correct me, this is the first ACICA45, HK45 collaboration, at least going back as far as I've been involved in HK45. So this is fantastic. I'm also particularly pleased that it's taking place in Adelaide. I know that being an Australian from Brisbane, Adelaide doesn't always get a lot of airtime on the Australian arbitration circuit. So I'm particularly pleased that Littman Karras stepped up and offered to do this event in person in Adelaide. So I'll leave it at that. Thank you very much. And I'm looking forward to a great panel.
Thanks, Mariel. And look, it's fair to say that in setting up ACICA45, we really look to Hong Kong 45 as the model to follow. So we're delighted to be collaborating today. So our panelists today, first we have Sam Leeson at LK in Adelaide. So Sam's an associate at LK. He works on arbitration and related court proceedings in principally in the construction projects, and particularly in a PPP context. He was previously the associate to the Honourable Justice Lyons in the Supreme Court of Victoria, who was at the time the deputy judge in charge of the arbitration list. And in this role, Sam assisted His Honour in a range of arbitration-related matters, including enforcement and stay applications. And he's a member of our ACICA45 steering committee. We also have Julianne Malice, well, based in Hong Kong, but also Perth. She's a senior associate at Holman Fennick in Hong Kong, and she's currently on secondment to contractor Mondelphus in Perth, Western Australia. She practices as a disputes lawyer, primarily focused on the construction, engineering, energy and resources, and major infrastructure sectors. She's experienced acting for government, principals, contractors, subcontractors, and that's in litigation, arbitration, and adjudication proceedings. And she recently co-authored the Hong Kong and Malaysia chapters of the International Application of FIDIC Contracts Practical Guide. Third, we have Robert, or I'll probably call him Robbie Williams. Robbie is a barrister and a member of Hanson Chambers in Adelaide and List A barristers in Melbourne. He's acted in a significant number of Australian domestic arbitrations, mostly in the construction and engineering fields, together with related court proceedings. He's also acted in a number of international arbitrations, including investor-state arbitrations. He's an associate member of ACICA and a member of ACICA's South Australian State Committee. And finally, we have Jennifer Wu. Jennifer is a senior associate at Pinsent Masons in Hong Kong, specialising in international commercial disputes, in particular in the technology, science and industry sector. She has a particular focus on cross-border cyber technology and data governance related claims and disputes. You're protecting systems, software and information held online for businesses. She's been commended for her handling of disputes in complex projects and cross-border matters in various jurisdictions, including the US, Europe, England and Wales, China, across ASEAN, Korea and India. She's considered a thought leader in the global technology digital market space. She's qualified in England and Wales and Hong Kong, and is a member of the HK45 committee. So with those introductions, we thought we would kick off the discussion today by focusing on, what does it mean to be pro-arbitration? Because whenever discussing the role of courts in supporting arbitration, we often talk about that term being pro-arbitration, but what does it really mean? And we thought we'd explore that with the panelists. So Sam, I'll start with you. What does pro-arbitration mean to you?
Thanks, Chad. I always think of pro-arbitration as really an acknowledgement by the court that its role is to support arbitration processes rather than to impair or intervene in the arbitration or necessarily critically analyse what the arbitrator is doing. For me, this is probably enshrined most readily in the principle of minimal curial intervention in Article 5 of the model law. In essence, the idea is to leave matters in the hands of the arbitrator and I suppose prevent parties from circumventing the arbitral process to which they'd previously agreed. So for this reason, processes like interim measures ordered by the court are really only used to support arbitration processes and are said to be used sparingly because it really does infringe on the way the case is managed by the arbitrator and really what the arbitrator, who at the end of the day has been appointed to determine the dispute, can do. So for the same reason, the courts will also refer a dispute to arbitration that's subject to a valid arbitration agreement. From the Australian perspective, I suppose the legislative intention domestically has always been to maintain a pro-arbitration perspective. The court's powers are limited in our domestic acts, the Commercial Arbitration Acts, to what is provided for by the Act. And Victoria's Act is probably the best example of this, where Section 40 of that Act expressly excludes the inherent jurisdiction of the court. This is probably reflective of the position in other states, even though there's no express provision for it, and certainly has been held to be so in Western Australia by their Court of Appeal. And I think logically would apply equally to the application of the model law to proceedings in an international arbitration context. From a practical perspective, what I think the court does to be pro-arbitration is really captured by the importance that they place on their arbitration lists and specialist judges to deal with arbitration-related court proceedings. The idea is that this leads to a more consistent application of the law because arbitration-related proceedings go to judges who are familiar with arbitration-related matters and more fulsomely understand the role of the courts in arbitrations. This is probably contrasted with the idea of where you don't have an arbitration list, simply sending it to a general commercial list or a general interim applications list. The other sort of practical effect of this is that it hopefully expedites the progression of arbitration-related proceedings through the courts, so that parties can either get on with their arbitration or obtain the benefit of an award more quickly. Looking sort of internationally as to what this means, one of the benefits that this has led to in Australia is that our judges, and particularly our specialist arbitration judges, are fairly good at drawing on the development of arbitration-related jurisprudence from other pro-arbitration jurisdictions, including Hong Kong. And I know in particular in Victoria, Justice Croft was really big on this during his time on the Supreme Court, and on the federal court now, Justice Stewart is very keen on the notion of drawing on international jurisprudence. I think the reason for this really is that it creates consistency in the application of the model law globally, and the more consistent the international application of the model law is, the more developed it becomes. And so the more developed the system is, the more confident people are that it functions, and therefore the more likely people are to use it. So I think those sort of practical steps that the courts have taken are, or embody what pro-arbitration means from my perspective.
Thanks, Sam. I mean, there's quite a few elements that you've taken us through there. I want to keep us in Australia just for the time being before we hear the Hong Kong perspective. You know, Robbie, do you agree? What would you add? And perhaps relatedly, they say, you know, sometimes you have to be cruel to be kind. Does that apply here? Can it be pro-arbitration to strike down an award? When would that be the case?
Yeah, thank you very much, Chad. I would very much agree with the comments that Sam has just made, particularly sort of his two sort of critical propositions. One, that that pro-arbitration courts need to adopt practical measures, and particularly his comment about expedition and the need for expedition. That to me, particularly in terms of interim or interlocutory steps, is fundamental. When you look at the types of issues that people go to the courts in support of arbitration, whether it's subpoenas or some sort of interim measures, security for costs, those kinds of applications, they're applications that you want dealt with quickly, efficiently. And so those are critical. And as Sam has said, some jurisdictions in Australia, Victoria, New South Wales, obvious examples, do have those specialist lists, specialist practice notes and the like to enable those steps to take place. In terms of your cruel to be kind question, Chad, there's a relatively recent decision from the full federal court called Hub Street Equipment and Energy City Qatar Holding Company. It's a decision of Chief Justice also, Justice Middleton and Justice Stewart, that was handed down a few months ago. And it's a case where a Qatari entity obtained an arbitral award from an arbitration in Qatar against an Australian company, and then sought to enforce that award in Australia. And I'll try to explain the facts as shortly as I can. But in brief, there was an arbitration agreement in the parties' commercial contract, and that required the parties appoint the tribunal. So in the usual way, applicant appoints one, respondent the other, and those tribunal members appoint the third. What happened in that case, though, was the Qatari company short-circuited that process for its own reasons and went to the Qatari courts and had them appoint the tribunal. That tribunal then heard the arbitration. The Australian company received notification of the arbitration, but chose, or didn't participate in it. An award was granted in favour of the Qatari company, which it then sought to enforce in Australia. And the matter, as I said, came on before the full federal court. And the issue, and there are a number of arguments raised, but the issue that was fundamental to the federal court's decision in deciding not to enforce the award was the fact that the key appointment process of the tribunal under the contract hadn't been followed. And so what that meant was sort of a fundamental step in the arbitral process hadn't been satisfied. And the court sort of noted New York Convention principles and it does the very strong desire to enforce awards, and went through, dealt with issues such as judicial comity and not wanting to show disrespect to the Qatari court that had appointed the tribunal. But ultimately, it found that this was such a fundamental issue. It goes to the heart of arbitration, the appointment of the tribunal and the correct appointment of the tribunal, that it determined not to enforce the award. And I think that's a sort of an excellent cruel to be kind example, because it shows the courts saying, well, we're not just going to enforce, but let's take a step back. What's fundamental to arbitration and what's fundamental is giving effect to the parties' agreement, and they're including their agreement to arbitrate, and they, as part of that, the critical aspect of how they're going to appoint their tribunal and how that tribunal is going to obtain its jurisdiction. So I would say that recent decisions is a very good example of the courts being cruel to be kind and still supporting arbitration whilst at the same time not enforcing an arbitral award.
Yeah, absolutely. It's a sort of an example par excellence of striking down an award, but being pro-arbitration in doing so. We need to hear from Hong Kong. Jennifer, Hong Kong's now well established internationally as a pro-arbitration jurisdiction. What is it that Hong Kong has done to establish that reputation, do you think?
I think a part of it has already been touched upon by Sam earlier when he mentioned the international jurisprudence. And Hong Kong courts has actually produced a wealth of cases which refers to and in support of the arbitration process and also the enforcement of the award. I think what the special part of Hong Kong is, it really recognises that when parties are choosing arbitration, they are almost undertaking to respect the enforcement of the award. So where, applications are being brought to the court's role is really to assist in a just, cost-effective and efficient resolution of disputes. And this is really enshrined in our statute as well, where the objects and principles of arbitration is set out in the arbitration ordinance, whereby it states that the objects of the ordinance is to facilitate the fair and speedy resolution of disputes by arbitration without unnecessary expense. So consequently, the court's role to really assist in arbitration proceedings are expressly provided for under the arbitration ordinance, and there are kind of limitations in terms of when the court would intervene. That there are limited circumstances, so I'll bring us through it. It's challenging the appointment of the arbitrator, or if the arbitrator is unable to act, jurisdictional challenges and applications to set aside the award, and also assisting in the taking of evidence, such as ordering a person to give evidence or producing documents, which my counterpart Julianne will cover later on in this session. The court has also continued its pro-arbitration support by its minimal curial intervention, something that is similar to the Australia position that Sam has briefly touched upon earlier as well. And in terms of this wealth of case law, what it brings is a set of quite clear principles as to when the court would give regard to when determining when to intervene or when to assist parties in arbitral proceedings. Some of these I'll cover very shortly and elaborate on them as well. So the primary aim of the court is to facilitate the arbitral process and to assist in the enforcement of the awards. There are limitations as expressly provided for under the arbitration ordinance, which I've just covered. With regards to having regard to the objects of the arbitration ordinance as well, which is always to make sure that there's a fair and speedy resolution of disputes by arbitration without unnecessary expense. And in terms of the application to set aside, there are an exhaustive grounds set out under section 81 of the arbitration ordinance. In dealing with applications to set aside an arbitral award, whether on the grounds of not having, given notice or inability of one's party to present a case, or that the composition of the tribunal or the arbitral process was not in accordance with the parties' agreement, the court is only really concerned with the structural integrity of those proceedings, and they would have had to find it really serious to intervene, and that would only really have to be in cases which undermines the overall process of the arbitral proceedings. Even if the grounds are actually made out by one of the parties, the court does have residual discretion as to whether to allow enforcement of the award. And I think that is really reflecting on the court's overall approach in respecting the parties' autonomy, where they have actually chosen arbitration as a means to resolve their disputes. Thanks, Chad.
Yeah, thanks, Jennifer. Julianne, you've now practiced in both Hong Kong and Australia. How would you compare the pair? Do you think the approach of the Australian judiciary is now on par with that of Hong Kong?
Thanks, Chad. So before I touch on the judiciary in Hong Kong and Australia and their approach in terms of, well, at least their approach to arbitration, it's worthwhile first noting that it's been a little over a decade, but both the Hong Kong and Australian governments and the Singapore government, for that matter, implemented significant arbitration reform with a view to modernising and clarifying existing arbitration law and practice and promoting their jurisdictions as attractive arbitral seats. So as part of this reform, Australia adopted majority of the 2006 amendments to the Untituled Model Law in its International Arbitration Act, which brought it in line with its Hong Kong and, again, Singapore counterparts. Whilst the reform itself was some time ago, I think it's important to highlight in any comparison of the two jurisdictions that the provisions in their respective international arbitration legislation and regimes are principally based on and consistent with the 2006 model law. So moving on to the approach of the judiciary, whilst certainly historically there's been a perception of that some Australian courts have hindered effective commercial arbitration in being too interventionist, I think that view is actually now outdated. There's certainly been a notable shift in the attitude of Australian courts towards greater judicial support and less judicial intervention in the arbitration process. So to your question, I would say, yes, the judiciary in the two jurisdictions are actually more on par than one might think, although, naturally there are some nuances. So on that basis, for example, I think it's fair to say that both the Australian and Hong Kong courts are, and particularly in recent times, the Australian, in the case of Australia, actively pro-arbitration and pro-enforcement in their judgments and act in a manner that facilitates the arbitration process. In relation to being pro-arbitration, as Sam has already touched on, a number of superior courts in Australia, including the West Australian Supreme Court, the Victorian Supreme Court and New South Wales Supreme Court, and the High Court in Hong Kong, all have a dedicated specialist commercial arbitration list, which deals with matters arising under the respective arbitration legislation. In addition, the Federal Court of Australia has established an international commercial arbitration sub-area within the commercial and corporations national practice. with a dedicated group of federal court judges with special expertise in international arbitration. Similarly, the Hong Kong High Court has developed a group of specialist judges as well, which are responsible for dealing and disposing with arbitration-related cases. So, as Sam has already made the point, but I want to make it again because I think it's an important one. These measures ensure that the judiciary developing arbitration jurisprudence have a good degree of familiarity with the law and practice of international arbitration, and also it helps and it assists with arbitration related matters being disposed of expeditiously. Both jurisdictions also have generally taken a pro-arbitration approach to the interpretation of arbitration clauses, construing them broadly in favour of arbitration and in favour of covering all matters and disputes between the parties. So in respect of Hong Kong has adopted the Fiona Trust Presumption. For those of you who aren't familiar with that, under the presumption, the approach to interpretation of arbitration clauses is that it starts from the assumption that parties, as rational businessmen, are likely to have intended under any dispute arising out of the relationship into which they have entered or purported to enter to be decided by the same tribunal. This presumption, of course, it is rebuttable, and Lord Hoffman outlined, or at least qualified in his decision in Fiona Trust, that the presumption should not apply where the language makes it clear that certain questions were intended to be excluded from the arbitrator's jurisdiction. So whilst the Fiona Trust presumption hasn't been adopted in Australia, so that's an example of a nuance and a point of difference. The High Court in Australia has recently confirmed in the case of Reinhardt and Hancock Prospecting that Australian courts shall construe arbitration clauses widely and taking into account the language used, the surrounding circumstances, and the purposes of the contract. This in-context approach to contractual interpretation is consistent with the Fiona Trust presumption. So in the Reinhardt decision, the High Court of Australia held that claims concerning the validity of deeds containing arbitration clauses fell within the scope of the arbitration clause itself. So the court placed, in that case, the High Court placed a particular emphasis on confidentiality being a serious concern for the parties in the dealing leading up to the entry into the deeds. And therefore, having regard to the circumstances and the purpose of the deed, the court was of the view that the parties could not have understood that the disputes concerning the validity of concerning the validity of the deeds would be determined in the public spotlight and ventilated in open court. And so for that reason, they upheld the arbitration clause. Having said that, Australian courts will still, notwithstanding this in-context approach, consider the natural and ordinary meaning of words in an arbitration clause. Therefore, where parties have agreed to a narrowly drafted arbitration clause, which was the case in a recent New South Wales Court of Appeal decision of Ingham Enterprises and Hannigan. Sorry, my email's just gone off. Sorry about that, everyone. Where was I? So so in this recent New South Wales Court of Appeal decision, the arbitration clause was quite narrowly drafted, and it provided that it covered any monetary amount payable and or owed by either party to the other under this agreement. And basically the court held that, when you have a narrowly drafted clause, then only the specific disputes referred to in the clause may be referred to arbitration. So in that case, whilst the parties could pursue arbitration in relation to the amounts payable and owed under the agreement, they couldn't pursue claims for unliquidated damages because it wasn't expressly specified in the clause. And then finally, in relation to the judiciary in Australia and Hong Kong being pro-enforcement, I mean, an obvious box that that both jurisdictions tick is that they are signatories to and have implemented the New York Convention. And in addition to this, as Jennifer has touched on, under the arbitration ordinance in Hong Kong, and also similarly under the International Arbitration Act in Australia, there's very narrow grounds prescribed for resisting enforcement or challenging an arbitral award. But I would say, more importantly, the judiciary in Hong Kong and Australia have both made it very clear and made very clear statements that they will narrowly resist the grounds of enforcement. They will narrowly resist challenges to the grounds of enforcement of arbitration awards. So Jennifer went through a few principles, and I take it that she had extracted those from Madam Justice Mimi Chan's decision of KVS and S. So I won't take you through them again, but just to make the point that you know, the primary aim. Madam Justice Mimi Chan, she had she basically had 10 principles that she set out, which she said which reflected the court's attitude towards enforcement of arbitration awards. And the key one is the primary aim of courts is to facilitate the arbitration process and to assist with the enforcement of arbitration awards. And then secondary, the court will only interfere in arbitral disputes as expressly provided for under the arbitration ordinance. Whilst the judiciary in Australia hasn't been as crafty as Madam Justice Mimi Chan in developing 10 golden rules or commandments, they've also made, I think in my opinion, their pro-arbitration stance very clear. So for example, in Uganda Telecom Limited and High Tech Telecom, Justice Foster held that it is not against public policy for a foreign award to be enforced by this court without examining the correctness of the reasoning or the result reflected in the award. The whole rationale of the Act being the International Arbitration Act, and thus the public policy of Australia, is to enforce such awards wherever possible in order to uphold contractual arrangements entered into in the course of international trade in order to support certainty and finality in international dispute resolution. So that's all from me, Chad.
Yeah, thanks so much, Julianne. I think that was that was a really great distillation of the similarity and then some of the nuance, and we're going to flesh out some of that nuance as between Australia and Hong Kong. So moving away from the general to the specific, I think it's now generally common ground that both Australia and Hong Kong are, or at least they certainly profess to be pro-arbitration. They're also both model law jurisdictions, but that doesn't mean that interactions with the court in those places are exactly the same. So let's explore the topic of indemnity costs. So Jennifer, what's the position of the Hong Kong courts on indemnity costs in respect of challenges to arbitral awards?
So in terms of the Hong Kong courts, they've developed an indemnity cost rule, mainly really to deter meritorious attempts to challenge enforcement of arbitral awards or to undermine the effectiveness of the arbitral proceedings itself. I understand that this practice has not been firmly established in any other jurisdictions in the region, but I'm sure Chad and Robbie will Robbie and Sam will correct me later on if I'm wrong. So how does this indemnity cost rule apply in Hong Kong? Well, it applies where a party unsuccessfully resists enforcement of or challenges to an award, and this includes where a party unsuccessfully makes an application to set aside arbitral award. It also applies where a party unsuccessfully seeks to reopen through court proceedings an issue that has already been dealt with by the arbitral proceedings, and this could be where the subject matter has already been dealt with by the arbitrator in its final award. In such circumstance, the court has made it quite clear that it would order indemnity costs to be paid unless special circumstances exist, and that those would be very rare circumstances, and the bar is quite high. And it is always noted that at the end of arbitral proceedings, the arbitrator and the tribunal always has discretion to assess costs and also to allow for costs that are reasonable under the circumstances. So when the tribunal has already determined the cost of the arbitral proceedings, and that is challenged by one party and is brought to the court, if that party is then unsuccessful, the indemnity cost rule would almost certainly apply in Hong Kong.
Thanks, Jennifer. And Robbie, what's the position in Australia?
Thank you, Chad and Jennifer. The position in Australia is very different from that in Hong Kong, and perhaps is moving further away from the Hong Kong position, at least in Victoria. By reference to two relatively recent decisions, the first is a 2016 decision by Justice Beach of the Federal Court in Sino Dragon and Noble Resources. And in that case, Noble Resources put forward the Hong Kong position that there was in fact a special rule that, absent these special circumstances, indemnity costs should be awarded where a party makes an unsuccessful challenge under Article 34 of the Untitled Model Law. And that contention, Justice Beach found quite compelling, but ultimately rejected it for a number of reasons, including that there's no such provision in the model law, and there's no such provision in the relevant Australian legislation, and so therefore you come back to the law of the forum and consider sort of public policy issues in the law of the forum, and ultimately sort of His Honour didn't consider that there were reasons why Article 34 challenges should be treated differently from sort of other cases. That said, His Honour sort of adopted perhaps a midway approach in saying that where you have a case where there's an unsuccessful Article 34 challenge, and it was found to have no reasonable prospects of success, regardless of whether or not the party knew that, then those circumstances would be ones that would justify an order for indemnity costs. So it still puts pressure on the party wanting to make a challenge in circumstances where they don't have reasonable prospects of success. That decision, amongst others, was considered relatively recently by Justice Reardon in the Victorian Supreme Court in the case of Winslow Constructors and Transport for Victoria. And there, Justice Reardon essentially determined that there was no basis for departing from usual cost rules under Australian law, and also didn't adopt Justice Beach's sort of consideration of no reasonable prospects of success test. And His Honour said that he thought that kind of test was probably unlikely to discourage litigants from pursuing an Article 34 challenge, and what he thought might be more effective would be courts ordering penalty interest, I should say, or otherwise trying to manage Article 34 challenges on an expedited basis to really sort of push them through and get them dealt with quickly and efficiently. And in that case, His Honour simply awarded costs on the standard party basis. So there was no indemnity costs awarded. So it seems from that recent decision that Australia, or at least Victoria, is moving further away from the Hong Kong position. But perhaps, but at the same time, the courts are certainly alive to how they should deal with unmeritorious challenges, Article 34 challenges. So perhaps there'll be some developments in that area, but perhaps not through the use of indemnity costs.
So, Sam, can we reconcile Australia's position on indemnity costs with Australia being a pro-arbitration jurisdiction? I mean, is this a case of supporting arbitration while staying true to our principles, or is this an area where Australian law has another evolution yet to come before it's fully pro-arbitration?
Thanks, Chad. I think prior to Justice Reardon's decision, I would say it's much easier to reconcile the position in Australia with being pro-arbitration. However, it's not necessarily impossible. I think really for two reasons you can reconcile our position on indemnity costs with being pro-arbitration. And the first one is really based on the fact that part of what underpins all of what we've said so far on what is being pro-arbitration is that the courts are in favour of arbitrations that are constituted and conducted pursuant to a valid arbitration agreement. So it's not simply for a court to rubber stamp any award that they get or to immediately stay any application. And this idea that a valid arbitration agreement or an arbitration is to be conducted pursuant to a valid arbitration agreement is a constant theme in the provisos for the exercise of the court's powers, which are built into the articles of the model law. Turning to sort of the specific question of indemnity costs, as Robbie explained, Justice Beach's midway in Sino-Dragon, really part of the principle behind that is that the unsuccessful party in, for example, a stay application or an application for refusal of enforcement may not necessarily have advanced an argument that was on its face hopeless or bound to fail. It's just that it did fail in the circumstances of the case. And in that scenario, perhaps a more, or the midway approach might be more, or might be able to be reconciled with being pro-arbitration, because it means that parties aren't necessarily discouraged from challenging an application where there's a genuine dispute as to the validity of the underlying agreement, simply due to the threat of an automatic indemnity costs order. Of course, dealing with that point in light of Justice Reardon's comments is perhaps difficult. However, the idea of penalty interest is perhaps another way of dealing with the same issue. On the sort of second reason behind this, I think Justice Beach did go to some lengths in Sino-Dragon to discuss the Australian position on indemnity costs as a matter of public policy. And he referred to this as distinct from something to be internationalised, were his honest words. And I think really, if it is the case that the award of indemnity costs is a matter of public policy, then the model law acknowledges that it exists alongside the public policy of the forum and applies consistently with that policy. So you get carve-outs for example, enforcement applications where enforcement might be refused if it's contrary to the public policy of the forum. So I don't think it's necessarily an anti-arbitration approach to take the sort of negative or negatively phrased view that Australian courts take into account the public policy of how they award indemnity costs. And certainly to the extent it is a public policy issue, doing so is consistent with the provisions of the model law. And it sort of leads into a question of whether or not it is always pro-arbitration to take an international approach, or whether there are circumstances where it might be pro-arbitration to take a national approach. But as to whether there's another evolution to go in Australia, I can certainly see a scenario where, as Australia develops a reputation as an arbitration-friendly jurisdiction and potentially moves sort of toward the same sort of approach as Hong Kong. The policy considerations change to weigh in favour of awarding indemnity costs as a presumption, or as a rule, as in Hong Kong, for arbitration-related proceedings, simply because the policy of being pro-arbitration may then outweigh the policy of not, or the presumption of not awarding indemnity costs. I don't necessarily think that means Australia's position is not pro-arbitration at present, but it's simply just a separate balance of two different policy considerations in Australia at present.
Yeah, thanks, Sam. I think that was a spirited defence. Well done. So to round out today's discussion, I'm very happy to say that we have preempted and picked up one of the listener questions that have come through on the chat. We want to talk about the role of courts in supporting tribunals to obtain evidence, and principally that's through the granting or the issuing of subpoenas in support of an arbitration. And we wanted to talk about that in particular in the context of issuing subpoenas in support of foreign-seated arbitrations. Now, you would expect, given what we've heard about both Australia and Hong Kong being so decidedly pro-arbitration, that our courts would offer subpoena support in respect of evidence located within their jurisdictions, regardless of the seat of the arbitration. Julianne is going to talk through the issue with both her Hong Kong and Australian hat on. So over to you, Julianne.
Thank you very much, Chad. So if I could make some preliminary observations at the outset before I delve into a discussion on the position in Australia and Hong Kong and what I consider to be a gap in the court's power in both jurisdictions to assist in obtaining evidence in relation to foreign-seated arbitrations, particularly where, as I've spent a good 10 minutes before trying to convince everyone, both jurisdictions are very much pro-arbitration. So first, and I imagine the rest of the panel would agree when I say this, subpoenas are a powerful tool for litigation and arbitration, and they play a very important and crucial role in the administration of justice. They can be used to compel parties to give evidence or produce documents which would not otherwise be available to parties in a dispute. Being a constructions disputes lawyer, cases, particularly large construction cases, often turn on documents being held up or down the contracting chain. So being able to have access and being able to obtain third-party documents is often critical to a claim. And so the importance of this gap in the position in both jurisdictions, I think, cannot be underestimated. Second, arbitral tribunals don't have a power to compel a third party to give evidence or to produce documents. They rely on the assistance of courts that exercise jurisdiction over the relevant third parties to issue subpoenas to them. And thirdly, by its very nature, being international arbitrations will necessitate obtaining evidence from outside the jurisdiction in which the arbitral proceeding is seated. So moving on to Australia, the Australian court's power to issue subpoenas in respect of arbitral proceedings, and in particular in respect of foreign-seated arbitrations, was considered in Samsung C&T Corporation, re-Samsung C&T Corporation in 2017. For reasons I'll come to shortly, Justice Gilmore held that the Federal Court of Australia did not have jurisdiction to issue subpoenas in support of foreign-seated arbitrations. By way of some background, Samsung C&T Corporation and Duro Felguera Australia were parties to an arbitration seated in Singapore, governed by the Uncentral Arbitration Rules 2013 and administered by the Singapore International Arbitration Centre. It was concerning various disputes arising out of the construction of the Roy Hill iron ore mine in the Pilbara of West Australia. It's worth emphasising that there was an overwhelmingly strong nexus with Australia. The parties had places of business in and conducted business within Australia. the governing law of the dispute was Western Australia, and the project, of course, being in the Pilbara region, was in Australia. Incidentally, I actually was part of the team of solicitors who acted for Juro, although I was so focused on the arbitration itself that I wasn't involved in this particular application. As for the procedural background, so following obtaining permission from the tribunals, Samsung brought 2 applications for leave to issue subpoenas under Section 23 of the International Arbitration Act in the Federal Court, both which were considered by Justice Gilmore. Section 23 of the Act permits a party, after receiving permission from the arbitral tribunal, to apply to a court, being the operative word, to issue a subpoena in aid of international arbitration. The provision is based on and similar to, but it's not identical to, Article 27 of the Model Law. Whilst Justice Gilmore granted leave in respect of the first application, which was in March 2017, later that same year, he refused to grant the second application, determining that his previous decision to grant leave was clearly wrong, and that the Federal Court of Australia did not, in fact, have jurisdiction to issue subpoenas in support of foreign-seated arbitrations. In reaching his decision, Justice Gilmore considered the interpretation of the provision immediately preceding Section 23 of the Act, which was Section 22A, and in particular, whether the Federal Court of Australia was a relevant court for the purposes of determining a subpoena request in a foreign-seated arbitration. So Section 22A, not to bore you, but I just need to set it out, it's quite important, defines the word court as A, in relation to arbitral proceedings that are or are to be conducted in a state, the Supreme Court of that state, and in relation to, and B, in relation to arbitral proceedings that are or are to be conducted in a territory, the Supreme Court of that territory, or if there is no Supreme Court established in that territory, the Supreme Court of the state or territory that has jurisdiction in relation to the territory, and in any case, the Federal Court of Australia. So Samsung contended that the phrase "in any case" in Section 22A of the Act should be read to extend the jurisdiction of the Federal Court to include foreign-seated arbitral proceedings. Justice Gilmore disagreed, determining that the proper construction of 22A and 23 of the Act supported a construction that the power to issue subpoenas under the International Arbitration Act only applies to arbitral proceedings commenced in a state or territory of Australia, so therefore a domestic seated arbitration, as opposed to a country, another country as being the state. So His Honour then held, His Honour held that Samsung's contention or proposed interpretation of Section 22A was too broad, and that it unnecessarily read words of significance into the Act and into Section 22A. So in coming to that view, Justice Gilmore pointed to various parts of the Act, for example, Part 2, in which the Australian Parliament had expressly expanded the court's jurisdiction by reference to geographical location and, including words such as foreign awards, whereas that was absent in Section 22A. Anyway, he then went on to comment that Parliament intended that Section 23 intended that Section 23 cover arbitral foreign-seated arbitral proceedings. It would have expressly included words to that effect. And he also actually held that Section 23 to read words into Section 23 that weren't there would, amongst other things, be inconsistent with the purpose of the Act, which was to encourage international arbitration seated in Australia. So one of the concluding remarks that Justice Gilmore had was that that when you have a foreign-seated arbitration, perhaps the best route to go to is the Hague Convention on Taking Evidence Abroad, and that could perhaps be an alternative to seeking a subpoena under Section 23, and I'll touch on that shortly. Whilst I certainly see force in Justice Gilmore's reasoning, and I think on balance it was the correct decision taking into account the interpretation of the Act itself, it's hard to ignore that the decision just seems to be at cross purposes with the object of international arbitration. Moving on to, so that was the only decision of significance in Australia on this, and I think it's pretty clear what the position is. So moving on to the Hong Kong position, it might surprise some of you to know that the position in Hong Kong is equally as limited in respect of foreign seated arbitrations. So whilst there's been no judicial authority on point in Hong Kong, like we have, with the Samsung decision, that's probably because the position in Hong Kong is pretty clear. In terms of this position, so Section 55(2) of the arbitration ordinance in Hong Kong provides that the court may order a person to attend proceedings before an arbitral tribunal to give evidence or to produce documents or other evidence. So this again is similar but not identical to Article 27 of the model law. Whilst the only limitation in Section 55 subsection 2 is in relation to compelling witnesses and other persons who are within the jurisdiction of the court's jurisdiction in Hong Kong, Section 5 subsection 2 of the ordinance actually expressly and clearly limits the application of most of the arbitration ordinance to arbitrations that are seated in Hong Kong as opposed to arbitrations seated in foreign jurisdictions. So basically, whilst you've got Section 55(2) there, it just doesn't apply. Whilst there is, notwithstanding Section 5 subsection 2, certain powers available to courts in Hong Kong, which may assist parties to foreign seated arbitrations in obtaining and preserving some evidence, these powers are relatively narrow and limited. So for example, there is no power in respect of compelling witnesses to attend, or no express power concerning the actual production of documents. For the sake of completeness, I'll just highlight what the powers are. So there is a power under Section 45 subsection 2 to grant interim relief to parties in relation to arbitral proceedings seated outside of Hong Kong, including a power to grant a search order to permit identified persons to search for and to seize evidence. But there's a caveat on this power because the court can only grant interim relief under the provision if the arbitral proceedings are capable of giving rise to an arbitral award that may be enforced in Hong Kong under the arbitration ordinance. And then there's also a power under Section 60 subsection 1 to make an order in relation to, and again, arbitral proceedings outside of Hong Kong. And such order would be one to direct the inspection, photography, preservation, custody, detention, or sale of any relevant property by the arbitral tribunal or by any by a party to the proceedings, or also an expert. But again, the word property isn't defined under the arbitration ordinance, so it's not clear whether this would capture the production of documents. I mean, there is some commentary that suggests that it may, but it's certainly not a clear and defined power. And in any event, it's only a power to inspect or to preserve. It's not a power to produce documents. So whilst I've referred to the position in Hong Kong and Australia as a gap, it is in essence a reflection of the position under the model law, which constrains a party from seeking evidence from another jurisdiction by designating that a request be from the competent court of this state. In my opinion, that's somewhat unsatisfactory, because the whole nature, as I mentioned, of international arbitration is that it's international, and parties are invariably going to be located in various different jurisdictions, and with the behind the concept of consent, parties are entitled to find a jurisdiction as their seat of arbitration that is neutral, and that effectively that the parties need to, without being able to obtain evidence from foreign jurisdictions, it just basically undermines the entire arbitral jurisprudence, in my view at least. So the million-dollar question is, what can a party to a foreign-seated arbitration do to obtain critical evidence in Australia and Hong Kong? Since the Samsung decision, a number of commentators came out and said that, this position needs clarification or it needs reform, but it's been over 4 years now, and Australian government at least hasn't done anything to amend or reform the Act. So it seems clear to me that the Australian position is to maintain the status quo. So I think perhaps the best answer for now is that if you need to obtain documents from another jurisdiction, parties need to think about this at the outset when they're negotiating their arbitration clauses, and give due consideration to what jurisdiction the documents are likely to be located, and should a dispute arise, how they can go about in obtaining critical evidence.
Thanks very much, Julianne. I mean, it's a vexing question, and I see from the chat a comment that there are some jurisdictions, the US most notably, that does allow that more expansive power. But just to play devil's advocate for a moment, let's suppose the parties have chosen as their seat Geneva or another of the European civil law jurisdictions, in which that sort of compulsory document acquisition, even from your counterparty, let alone third parties, is just not part of the process. Should there be a power to subvert that choice by attending at other courts? And I mentioned that just by way of sort of to round out our discussion today, that there is a bit of nuance when we think about what is the precise parameters of the role of the court. We hope you found today's discussion useful and helpful in illuminating some of those nuances. And it isn't always immediately apparent what it is to be pro-arbitration, or what it is to be the right approach that courts should be taking in supporting arbitration. I'm conscious of time, so I think we'll need to leave the discussion there. But if I could just ask everyone to join me in thanking our panelists today for a really illuminating discussion, and it's been fantastic to have you all here in person and virtually. Thank you very much.